Morning if you're joining us from the Pacific or Alaska time zones. My name is Colby Dern. I'm a staff attorney and legislative counsel for the National Congress of American Indians, and I'll also be your webinar administrator today. On behalf of the Trust Modernization Workgroup, we'd like to thank you for attending this webinar titled Modernizing the Trust, Redefining the United States Tribal Government-to-Government Relationship and Advancing Trust Asset Reform. Before we begin the presentation, I'd like to go over some of our webinar features. First, you should see on your screen the PowerPoint for today's presentation. If during the presentation you're experiencing any lag in the slide transition, it might be a result of the internet connection, so just give it a few extra seconds to update on your screen. Next, you'll see a PowerPoint slide that will look like the PowerPoint slide that you should have up on your computer. It's made up of two parts. There's the viewer pane on the left, which allows you to see the PowerPoint presentation, and the control panel on the right and the control panel is important for how you can participate in today's webinar. So let's take a look at how the control panel works. By clicking the orange arrow, you can minimize and also open your control panel. And from this view, you can also select and test your audio. Many of you have joined by telephone. You'll also have many different opportunities to be able to participate and ask questions and make comments today throughout the webinar. And to be able to do that, you have two options. First, if you've dialed in through the phone system, make sure you've entered your audio pin, and that way you'll be able to make your microphones live during the presentation. When you do that, you can hit the yellow and green hand raise button. That'll alert us to that you have a question, and then we can make your microphone live. You can ask the question over the phone. If you'd prefer, there's also a questions box on the control panel, and you can type your question and send it over there. We'll be answering questions throughout the webinar, and at the end of the webinar, everyone will receive an email about 24 hours afterwards with a link to the YouTube recording of this webinar and the slides that were presented, and you'll be able to email any other questions you have. We may not be able to get to all of the questions that are asked today, but our webinar system records all of them, so we'll be able to go back to those and answer those questions later. Now I'd like to introduce NCI's President, Brian Clasby, for some welcoming remarks.
Thank you, Colby, and good afternoon or good morning, whatever time zone you're in. Like Colby said, my name is Brian Cladesby. My traditional name is Speepots, and chairman of the Swinomish tribe. We're located about an hour north of Seattle, up here in the great Pacific Northwest. I'm also honored to be the president of NCAI, and just excited to welcome all of you and introduce you to all the work that we're doing at NCAI in concert with our partner tribal organizations. And a big shout out to all of our tribal organizations who have been working for many years on trust modernization, and one of my goals that I continually preach in DC is for the need to create 21st century policies that truly recognize true tribal self-determination, self-governance, and our inherent sovereignty, and policies that recognize us as 21st century tribes. And as many of you know, the antiquated laws and regulations governing the trust system have not, by many stretches of the imagination, come up with the modern realities of our tribal governments. And, you know, as many of you know, they're rooted in faulty, antiquated, paternalistic assumptions about Indian tribes and Indian peoples that date back to the 19th and 20th century. And we definitely need to move forward with this effort, and NCAI and our partner organizations collaboratively developed a set of draft trust modernization principles and recommendations for both administrative and legislative policy updates to streamline our programs, our budgetary requests, and at the end of the day, we need to definitely have more tribal control and better federal management. So I'm a firm believer that many tribes in the U.S. have the capabilities as governments not only to manage our own resources, but to develop our economies And we are showing that time and time again that when we have the opportunities, we know what's best for what we need here in our communities. But it's definitely a need to reform how the trust is administered and framed by the federal government. And the trust relationship must be based on the United States fully meeting its treaty and trust obligations while recognizing that tribes are in the best position to address the needs of all of our communities. And so the goal of this workshop is to establish a bedrock set of ideas that represent Indian country's vision for the trust relationship based on over a century plus of experience and the current realities of today. So the principles stem from many efforts throughout the past several decades and the collective input of our wisdom, of our tribal leadership over the years. And we will be further discussing and developing the draft principles at our NCAI mid-year conference in St. Paul, Minnesota on Sunday, June 28th. And I hope everyone on the call has the opportunity to join us there and continue the conversation that comes from today's webinar. So thank you for joining us, and it's my pleasure to turn it over next to my brother, the President of the United Southern and Eastern Tribes, President Brian Patterson, a proud member of the Oneida Nation of New York and a council member there also, for a few remarks. So President Patterson.
President Patterson, are you on the call?
Alrighty, President Patterson must be having technical difficulties, so maybe when he gets back on, we could go ahead and let him have an opportunity to speak when he gets back on. So I'll send him a text right now, letting him know that it's his.
I'm on. Hello. Hello.
There he is. Okay,
hey.
Turn it over to you, President.
Thank you, Speed Fox, for that nice warm welcome. I certainly appreciate your leadership, President Gladysby, on this issue and your willingness to work effectively across Indian country and all scopes on this issue. It is key and critical. So I'm from the Bear Clan, served on my nation council for over 25 years, and I currently serve as the United South and Eastern Tribes President. And so on behalf of our USAT family of tribal nations, I first wish to express my gratitude and appreciation for the thought, leadership, and commitment demonstrated by the many tribal leaders, organizations, and individuals that allowed for this Trust Modernization Initiative to come together and produce the draft principles and strategies document that we are reviewing during today's webinar. These documents are a compilation of the various trust modernization efforts that have occurred across Indian country over the years. Additionally, I want to thank NCAI and all their staff for all the work in putting together today's webinar. Collectively, we are fighting on a day-to-day basis to protect and promote our inherent sovereign authority across Indian country. When we take the time to pause and reflect on the many challenges that we continue to encounter today, we realize that the root cause is an antiquated trust model relationship, as President Gladysby inferred, that is not built from an Indian country-driven perspective. In fact, the remnant of a parentalistic mindset in tribal U.S. relations is the result. As expressed by former Assistant Secretary Kevin Gover in a 2006 Natural Resource Journal article, the current trust model is based on two false premises. One, that tribal nations are incompetent and unable to handle their own affairs, and two, tribal nations and its people would eventually assimilate into the broader society. As we can attest, both have been proven wrong. USAT has prioritized this trust modernization initiative because we believe that Indian country must deal head-on with the causes of our current barriers and challenges as opposed to only its symptoms. Too often, our time, resources, and energy is spent only on the symptoms, and then we wonder why progress is slow and incremental. USET further believes firmly that it is time to create a new reality in tribal U.S. relations, a reality that reflects our vision of a respectful nation-to-nation relationship and one that fully acknowledges our sovereign authority and rights without interference. We did not arrive at our current reality overnight. As you all know, it is centuries in the making. Many treaties, court decisions, and legislations have transpired during this time. I mention this only to acknowledge that we can't expect to fix this overnight. However, we must choose to make this investment of time and effort now to allow for the dividends and results of our efforts to pay off for the future generations that follow us. We all collectively hold that sacred duty, that sacred responsibility. Finally, today's webinar is not the end of a process. It is simply a beginning, a new beginning for Indian country. It is a starting point to establish unity across Indian country on our most important issue, a more secure and stronger future. Unity in practice must be achieved and realized for us to lead this issue forward. It is essential that Indian country proceed forward with one voice if we are to achieve fundamental and systematic change. So in pursuit of this change, we must not sit back and wait for others to define our destiny. We must be visionary and steadfast in our pursuit. That is our obligation. That is our sacred duty to our future generation. On behalf of the United South and Eastern Tribes Board of Directors, our tribal leaders, I thank you for joining today's webinar and look forward to your continued engagement and participation in this most important initiative. President Gladysby, NCAI, Colby, I turn it back to you.
Great. Thank you very much, President Patterson and President Clasby, for those welcoming remarks. Next, I'd like to introduce Kiki Carroll, who is the Executive Director of USET, for some introductory comments.
Good afternoon, everybody. What I want to do is just spend a little while giving you some background about how we arrived at today. And the summary I'm about to give is not to suggest that there have not been previous trust modernization efforts, but I want to start my remarks from where we began this initiative about a year or so ago. About a year or so ago, several organizations came together with the intent of learning from one another what work we were doing on trust reform or trust modernization. Since that time, that has grown to include several organizations, the Affiliated Tribes of Northwest Indians, the California Association of Tribal Governments, the Great Plains Tribal Chairmen's Association, Intertribal Council of Arizona, Midwest Association of Sovereign Tribes, the National Congress of American Indians, and USET. I mentioned those organization names just to let you know what regions are represented. If you are on this call right now and you feel that your region is not represented or actively represented, we strongly encourage you to work with your respective areas to actively join and participate in this initiative. The goal is to have a broad and diverse representation from Indian country in order to achieve a diverse perspective and input into this process. Over the years, tribal leadership across Indian country has engaged in trust modernization and trust reform dialogue and working documents to varying degrees. Our intent as the first step is to come together, work together as an organization on this initiative, and to merge our respective efforts together to create an initial working draft document that sought to be representative of the diverse interests and priorities of trust modernization and reform throughout Indian country. So the documents that you have on your webinar, the draft documents, are the result of those conversations. As both presidents mentioned in their remarks, our goal is recognizing that the current trust model reflects a different time and reality in tribal U.S. relations. The goal of our effort has been to create a new start, a new chapter in tribal U.S. relations. However, one that is written by us and reflective of our vision and preferences. And while we may not achieve everything we set forth in that vision, it is critically important that we not self-impose any limitations along the way. As President Patterson just mentioned in his remarks, the current trust model, as expressed by former Assistant Secretary Gover, is an antiquated model. one that believes that we were incompetent to handle our own affairs and that we'd eventually assimilate into the broader society. So it is time for a new trust model that's reflective of the current reality. And it has also been 40 years since the passage of ISDA. And during that time, Indian country has experienced significant growth and progress. However, there are still many challenges that exist, many of which are a result of the current trust model. So the question that we're posing today before everybody is, where do we go from here? How do we move from incremental progress to exponential progress? How do we build upon the success of ISDA and improve on its shortcomings? And part of the answer, in part, lies in bringing forward and refreshing the wisdom of tribal leaders over the last several decades, applying that wisdom in the context of today's realities, and looking to current leadership to vision and guide us in the present. Looking to past experience and knowledge, combining that with current experience and knowledge will help to ensure that we are building a strong model for generations to come. So what we're hopeful to achieve from today's webinar is to give everybody a summary overview of the work that has been done up to this point. As has already been stressed numerous times already on this call, this is a starting point. These are draft documents. Our goal is to share with everybody what we have pulled together thus far, and then we desperately want to hear from all of you about what your thoughts and comments are and suggestions that you have to make this more reflective of the broader interests of Indian country. So again, if you are on this call and you feel that your region has not been properly represented within this initiative, please take the time to bring this information back to your respective organizations. What we are going to do next, for those that are unaware, as a result of the Cobell settlement back in 2011, they chartered a Secretarial Commission on Indian Trust Administration and Reform. In December of 2013, there was a report released summarizing or going over the work that was conducted from that. We've asked Dan Rayburn, who's of counsel to the Navajo Nation, to give us a summary on the results of that effort.
Hello, this is Dan Rayburn. I'm a partner at Nordhaus Law Firm. We represent the Navajo Nation. I am most definitely not President Fawn Sharp. Former chairman and president of the Navajo Nation, Peterson Zaw, was also a member of the Secretarial Commission on Indian Trust Administration and Reform, or SITAR, along with Fawn Sharp and Stacy Leeds, citizen of the Cherokee Nation, dean and professor of law at University of Arkansas School of Law, as well as Tex Hall from the three affiliated tribes of Fort Berthold, and Robert Anderson from the University of Washington. This commission was authorized in December of 2009 in conjunction with the announcement of the Cobell settlement. Because of legislation required to affect that settlement and appeals, the commission was not actually chartered until August of 2011. The commission was chartered to do 6 things: conducting a comprehensive evaluation of the department's management and administration of trust administration system, reviewing the department's provision of services to trust beneficiaries, receiving input from the public, interested parties, and trust beneficiaries regarding this, looking at necessary audits for the department, as well as recommending options to the Secretary to improve the department's management and administration for trust assets, as well as considering provisions of the 1994 Trust Reform Act providing for termination of the Office of Special Trustee. The commission spent basically 2 years having extensive meetings and public hearings regarding this, hearing from experts around the country and tribes and trust beneficiaries, and issued their final report in December of 2013. Essentially, this was to recognize that while the Cobell settlement was helpful for addressing issues in the past, there needed to be an evaluation of how best to move forward. There were 6 specific things that the commission had in terms of its recommendations. They're outlined in the presentation before you. As noted, the first is review and amend federal law. The commission was particularly concerned regarding the Department of the Interior and Department of Justice's defense of trust mismanagement cases, and so the Commission was particularly concerned with ensuring that the federal government was properly respecting its trust standards as previously recognized by Congress. Second, the Commission recommended evaluation of a tribal consultation policy to improve the federal consultation requirements and standards that are already in place. Third, the Commission recommended developing a uniform consultation policy to ensure that this would apply across all federal agencies. Fourth, the Commission recommended restructuring the federal government's administration of trust assets in part through an independent Indian Trust Administration Commission to centralize those responsibilities and to provide greater coordination and elevated responsibility. Fifth, the Commission recommended improving the management, oversight, and accountability for that system, and in part through reintegration of the functions of the Office of Special Trustee as provided for in the 1994 Trust Reform Act. Finally, the Commission made recommendations regarding certain procedural changes.
All right, thank you very much, Dan. The next thing we're going to do is we're going to go through the draft principles for Indian Trust Modernization. There's 5 draft principles, and you can see them presented on your screen right now. Each one of them has corresponding strategies for implementation. For our presenters for this, for the first trust standard, which will be strengthening trust standards, that will be presented by Greg Smith, USED General Counsel. The second principle, which is strengthen tribal sovereignty, will be presented by Dan Rayburn. The third, strengthen federal management, will be presented by Will Micklin, the first Vice President for the Central Council of Tlingit and Haida. The fourth is strengthen federal tribal relations, which will be presented by Reed Chambers from Sinopsky and Chambers. And fifth will be strengthening the federal funding improves efficiency, which I'll be presenting. So to keep it going, I'd like to send it over to Greg for the presentation of the first standard.
Okay, thank you, Colby. Greetings, folks online and in the room. My name is Greg Smith, and I'm going to talk about the first of the principles that the working group identified, which is strengthening the trust standards. And that leapt out, and I think because many tribal leaders and many people in Indian affairs have a very common experience, which you may have had as well, of coming to Washington, and every federal official you speak to, whether a member of Congress or an administrative official, will use the words trust responsibility, will remark on their trust obligation, will elevate the importance of the trust relationship. But we often search hard to find where those high principles have actually affected federal actions in a way that tribes can rely on and that tribes can enforce in a court of law. In fact, we have found that the courts have established certain principles that narrow the scope of the enforceable components of the trust responsibility. All too often, the federal government is the trustee for major Indian country resources, but does not have the same fiduciary standards that you would find in the common law. In other words, they're not held to the highest possible standards. As folks know, the United States government acts as a legal trustee for the land and water rights of Indian tribes and individual Indian tribal members in certain circumstances. And these rights are of critical importance with regard to tribal sovereignty as well as tribal economic development. There's sort of an underlying deal that took place at its most basic level, which is tribes lost or ceded millions of acres of land. But in that process, the U.S. government repeatedly made commitments and assumed an obligation as the legal trustee for the protection of tribal lands and resources and for the benefit of the Indian beneficiary. That concept has echoed down through the years in various important federal documents. So in 1977, the American Indian Policy Review Commission recommended that Congress reaffirm and direct that all executive agencies administer the trust responsibility consistent with a set of specific legal principles. And two important concepts there, the notion that every federal agency has a trust obligation, and that that obligation shouldn't be some nebulous concept that makes people feel warm and fuzzy in a meeting, but very specific, something that can be pointed to and relied upon and ultimately enforced in a court of law if necessary. Subsequently, Secretary of the Interior Bruce Babbitt issued a secretarial order that outlined principles, once again, for the proper discharge of the trust responsibility, and those principles were later codified in the Department of Interior's manual, its sort of internal working book. In 2013, as has already been referred to, after a two-year review, the Department of the Interior's Secretarial Commission on Indian Trust Administration and Reform had as its first recommendation that the U.S. government clarify that, one, all federal agencies have a trust responsibility to Indians. And I'm sure many folks on the phone have gone into some of the federal agencies to discover that they're barely even aware of the vibrant Native community, much less their obligation to that community. The CITAR, as it's called, also stated that this trust responsibility demands a high standard of conduct, and third, that each agency is to place Indian interests before those of the agency and outside parties. That would dramatically transform the conduct of Indian affairs within the United States, and it's something that is theoretically within the power of the agencies today as we sit here. Hence, this is really the first of our 5 principles, strengthening the trust standards as they actually exist today. Secretary of the Interior Sally Jewell has issued a secretarial order that outlines additional guiding principles for honoring the trust responsibility. In the discussions of the work group, it was concluded that the next logical step is to ask Interior to comply with federal consultation requirements to develop and promulgate not more principles, but regulations. So enforceable regulations that would ensure that not only this administration, but all future administrations, and indeed all departments, offices, bureaus, and agencies of the federal government truly fulfill their trust responsibility. These regulations should be developed in full consultation with Indian country, and we would also call upon the Congress to develop and enact legislation to codify these trust standards as well. Again, with the goal of being more specific and more enforceable. So we have certain specific strategies. I think actually you can skip back to the administrative strategies that are action items that we think can be implemented. One is to have the President issue a special message and a related executive order on the federal trust responsibility and on federal trust functions. He has issued other orders, including on consultation, that have been very effective at changing the climate in Washington, and he could do so similarly in this situation. Further, I've already referred to Interior's ability to develop trust regulations in consultation with tribes. There has been past work done. There are documents like the Krulitz letter, which was a significant letter in trust discussions from 1978 that laid out the obligations of the federal agency and needs to be fully embraced and expanded upon. There is a history of debate with regard to the federal government's trust obligation and of dispute within federal agencies over how enforceable that is. And what we're really trying to do is to move the ball towards making these obligations more enforceable. And one way to do that is to have the solicitor of the Department of Interior issue what's called an M opinion, a memorandum opinion, which would be binding upon Interior and I think influential with other agencies, setting forth specific responsibilities and implementing specific standards. I've already referred to the legislative strategy, which is to bring this to Congress as well. That's probably a longer term strategy. The federal government is not quick to assume new responsibilities, but within the conversation that's occurred over hundreds of years between tribes and the federal government, this is a very important point, that the federal government needs to live up to these obligations and not be able to hide behind a nebulous cloud of very good and positive words.
Great. Thank you very much, Greg. At this time, we'll take a short period for any questions or comments. If you have any questions, you'd like to answer them over the phone, please make sure that you use the raise your hand function. You can also type questions into the question box and then ask them that way. So we'll just take a brief couple of seconds here. Okay, so without seeing any questions so far, we'll head on to the next principle. Again, if there's any that we didn't get to, we can also have those answered at the end. So I'd like to send it over to Dan Rayburn to discuss the second principle, which is strengthen tribal sovereignty. Dan?
Hello. As noted, this is the second of the 5 basic pillars of this initiative, strengthening tribal sovereignty, empowering each tribe to define its own path. The background for this is that since 1968, every Congress and president essentially has recognized that tribes are best suited to meet the needs of their communities because they know best what their issues are and how best to address them. And certainly over the last generation, there has been a significant amount of progress in enabling tribes to move forward and empowering them and recognizing their sovereign authority to manage their own affairs. The Indian Self-Determination Act, and more recently the Hearth Act, the Tribal Law and Order Act, the Violence Against Women Act, the Stafford Act, and so forth. And while all these particular acts have been very helpful in moving it forward, what is thought is needed is a more comprehensive approach which provides tribes more generally with real decision-making authority in the management in their own affair of assets, so that tribes themselves can decide what specific role that they want to manage in administering their own assets and their own affairs and fulfill that to the best of their ability. So to address this, there have been a number of specific strategies that have been proposed. We can go to the next slide. So on the administrative side, some of the things that have been suggested are expediting trust acquisitions, especially within reservation boundaries, as well as encouraging more tribes to adopt tribal leasing regulations under the Hearth Act. So no administrative changes, no statutes are needed for that. It's just a matter of raising the awareness and pushing for greater action under existing authorities. In addition, as a regulatory matter, one thing that has been noted is that it would be very helpful to have an executive order recognizing greater tribal authority, such as the prior Secretarial Order 3206 and 3225. Those specifically recognized tribal authority regarding implementation of the Endangered Species Act, but there is language in there that is particularly valuable and more broadly applicable in terms of recognizing that Indian lands are not federal lands and are not subject to the same controls as federal lands, and that tribes, that the federal government should recognize that tribes are the appropriate governmental entities for managing their own lands and tribal trust resources. On the legislative side, there is also a recommendation that there should be legislation that more broadly allows tribes to manage any or all of their own trust assets. So, for example, rather than just have Hearth Act regulations for surface leasing or Indian mineral development agreements or energy resource agreements, tribes that have particular resources should be able to manage those resources to the extent of their abilities to do so. This legislation, this proposal for legislation should establish tribal jurisdictional authority equivalent with other sovereigns and consistent with that, that should exclude state and local jurisdiction, especially regarding taxation. In addition, tribes should have greater authority over education of their own students, and consistent with the recognition of the need for greater improvements in education for tribal youth. Finally, whereas the Indian Self-Determination Act currently has a valuable but limited role in terms of federal agency contracting and compacting, it should be recognized that all federal programs regarding services to Indian country are contractable. In related matters, there should be expanded protection of off-reservation resources, especially for sacred places, consistent with federal trust acquisitions. There should be a cherry fix to ensure that tribal lands that go into trust actually can be in trust and stay in trust. More long-term is an idea of greater implementation of the United Nations Declaration on the Rights of Indigenous People, as well as more immediately protecting civil and voting rights by allowing tribes to establish and regulate polling places, such as the Department of Justice and Department of Interior have in fact recently proposed in legislation.
All right, great. Thank you very much, Dan. Do we have any questions on either principles 1 or 2? And I believe we have a question from President Patterson. President Patterson, are you there?
Yeah, I'm here. I'm especially pleased to hear of the UNDRIP principles. You know, that's such a broad scope, and Vice President Micklin's been working diligently on that scoping on behalf of Indian country. So thank you for that. I guess the question is, how do we have recommended steps in a process to recognize UNDRIP principles? So that's one question. I was wondering if there was any conversation regarding free and prior consent in the consultation process. Lastly, the White House Council on what is it called? The White House Council on Native American Affairs. We know what I'm talking about, or trying to talk about. Is there any effort to make that permanent with a seat for Indian country with that council? I'll pause there.
Regarding implementation of the United Nations Declaration on the Rights of Indigenous People, this is certainly part of a coordinated, the idea is to pursue implementation of this both at an administrative level and I think long-term at a legislative level. And I don't think that as much as we would like to be able to have it be immediately and fully incorporated into federal law, it is a long-term effort that we'll have to work on a piecemeal basis to the best of our abilities. Regarding the White House Council on Native American Affairs, that is going to be addressed in item 4 of the key principles and strategies discussion. I defer to others in case there are more comments in response to the question.
Yes, one additional thing I want to offer for everybody, just to make sure that we are all clear. What we're doing right now is giving you a very 30,000-foot view of the structure and the shape of what it is that we're trying to proceed with. What's important for everybody to know that there is much detail that goes to each one of these areas that we're discussing right now. So the question that was posed by President Patterson, as by example, with the White House Council on Native American Affairs, we know that that was a significant advancement in terms of strengthening tribal U.S. relations. But we also have heard very clearly from tribal leaders throughout their country their desire to further strengthen that venue and to make some improvements to that structure as well, and to also seek some permanency with that. So the details of things like that are embedded in each one of these specific areas. To the third point, President Patterson, that you raised on free and prior consent that ties to the consultation process, we are well aware of the consultation effort that goes on right now. What we've heard very loud and clear from tribal leaders, and as many put forward in some of their documents that they shared with us, as a way to continue to strengthen that venue as well, to make it beyond just checking off the box that you held the consultation, but achieving something much more meaningful. Issues like that are definitely embedded in each one of these areas. I will just say for everybody right now, if you are interested in getting more of the detailed information in terms of the documents that we use, the reports, the paper that is behind all these various points that we are going through today, please feel free to contact us and we can share that information with you as well.
Great, thank you. We have a couple of people who've typed in questions. The first question is from Kate Hoover, and she asked, is there an intent to include in the trust modernization strategy some response to litigation approaches taken by DOI and DOJ that have been inconsistent with the trust?
Yes, as some of you may know, this is Dan Rayburn. As some of you may know, that was the very first item that was addressed by the Secretarial Commission on Indian Trust Administration and Reform, and that was the basis for their recommendation that federal law should be clarified to reaffirm substantive obligations of the federal trust responsibility. So that is indeed recognized as the first and most important key principle and strategy for this effort. Greg, I don't know if you have more to add.
Good. You guys are good.
Greg says we're good.
All right, the next question we have goes back to the first principle, and it's a question from Tom Slosher. He asked, don't we need formal regulations to make the Secretarial Order 3206 enforceable, and in suggesting that an executive order may not be enough?
An executive order, while it would not certainly be going as far as regulations, it would be an improvement over the current secretarial order. If we can get regulations, just as if we could get a statute, that would be ideal. But the idea is to not aim for the sky and ask for all or nothing, but rather to try and seek to achieve what we can consistent with the principles so that we can achieve as much as possible.
May I just add to that, Colby? This is Reed Chambers from the Sanofsky Law Firm. I guess I get to talk later, but let me just elaborate a little bit on what Dan said. The group here that's making this presentation has been meeting in this room and various other places. Your USET meeting a couple of weeks ago, for example, the NCAI meetings, the mid-year meeting, and then the October meeting in Atlanta. And has been very strongly supporting the recommendations of Secretary Salazar's Trust Responsibility Commission to make concrete changes in this administration. And so what Dan's saying, I think, is very important, and I just want to add and amplify it a little bit, that I think it would be very important to get binding regulations issued by the Secretary of the Interior encapsulating the principles that were in Secretary Jewell's recent order of last fall. But those are not enforceable. And they would be enforceable if they were in federal regulations. Same with an executive order, that all Interior regulations could do would be bind the other Interior agencies to observe a duty of loyalty to Indian trust resources and not infringe on those resources, but order their own activities so that those activities protect any Indian trust resource that's impacted. An executive order, in one sense, could go further because it could bind other federal agencies, Corps of Engineers, the Forest Service, that do have impact through their activities on Indian trust resources. So that could be a complementary effort. There is about 19 months remaining in this administration, and at least I think the consensus of this group and the philosophy behind these recommendations is that Indian tribal leaders, if this is important to Indian country, push strongly in this administration to have those implemented.
Great. Thank you very much, Reed and Dan. With that, we'll go on to the third pillar, which is strengthen federal management. And for that, I'd like to welcome Will Micklin as the first Vice President of the Central Council of Tlingit and Haida. Well.
Thank you. And my name is Will Micklin. I'm of the Wolf people, Brown Bear Clan, Tekwedi, child of the Lake Ka and grandchild of the Kanakadi Raven. I'm first Vice President, Central Council of Tlingit and Haida Tribes of Alaska, and I volunteer as Executive Director for the California Association of Tribal Governments. And I'm going to speak to strengthening federal management for trust assets still subject to federal control. So today, a number of federal agencies continue to institute policies that affect all Indian tribes and allottees. This one-size-fits-all approach ignores the unique differences between the individual tribes and unique government-to-government relationship each tribe has with the United States under its own treaties and other agreements. Unfortunately, many of these federal solutions never get changed or abolished, even when tribes, and the report of the Secretarial Commission on Indian Trust Administration and Reform, detail the deficiencies and recommend specific improvements. For example, Congress established the Office of Special Trustee to provide temporary oversight to improve federal trust management. Now, more than 20 years later, the OST continues as a separate bureaucracy outside of Indian affairs oversight, despite the completion of its purpose and repeated calls to reintegrate Indian trust asset management as a further measure for it to be more efficient, effective, responsive, and accountable. This is a significant drag on critical tribal and allottee resource use and development. Also, while the United States has settled COBEL and most tribal trust cases and actively sought to reduce its trust fund management through these settlements, OST still employs hundreds of people and as of fiscal year 2015 has a budget of approximately $139 million. As to administrative actions that this group is recommending in probate and appraisals, the DOI, Department of Interior, should eliminate unnecessary appraisals and permit tribes to rely on independent certified appraisals and expedite probate of allotments. The Trust Commission recommendation for probate was to promote the use of alternative strategies to probates through streamlined Office of Hearings and Appeals requirements for probate files, revitalizing the attorney decision-maker programs, and consider legislative authorization of local forums with tribal courts. They also made a recommendation for appraisals to expand the use of per-approved third-party vendor solutions to effectuate common standard services on commercial timelines, a review of USDA appraisal methodology and policies, improvements to process of procuring and utilizing mass appraisals, expanding previously approved waiver authority, and increasing authority to waive appraisal or evaluation requirements for transactions involving competitive bids. For trust land title insurance, DOI should use a secretarial order regarding implementation of the Department of Justice title standards for acquisition of land in trust for Indian tribes, including clarifying application of the Non-Intercourse Act that the United States is a stakeholder for such title insurance policies and that tribal sovereign immunity waivers are not required. We know in California, we have been asking for a solicitor's opinion on title commitments that would be useful in clarifying the appropriate use of exceptions and requirements for title insurance companies. As to conflicts of interest, DOI should better address and avoid potential conflicts of interest regarding implementation of federal trust responsibilities. The history of trust fund and asset management by Interior and its bureaus, including the Bureau of Indian Affairs, is replete with instances where the interests of Indian tribes and individual Indian persons have been disregarded or discounted in favor of other interests for which the Department of Interior is also responsible or subject to third-party influence. The potential for conflict of interest extends to other federal departments and agencies outside of the Department of Interior that are constantly at odds with the interests of Indian tribes and individual Indian persons, including EPA, USDA, Treasury, and IRS, and recently Consumer Financial Protection Bureau and others. These conflicts of interest make it difficult or impossible for our federal trustees to conduct true and effective management of trust funds or trust resources or adequately protect tribal sovereign jurisdiction and authority. The Trust Commission report asserted that the trustee is a fiduciary in which the law demands an unusually high standard of ethical or moral conduct with reference to the beneficiary. The trustee owes a duty to act solely in the interests of the beneficiary and must not consider their own personal advantage. As to legislative actions for trust modernization legislation, this should sunset the Office of Special Trustee and reintegrate its responsibilities to provide clear and unified supervisory authority within Interior for Indian trust management, and should improve lease compliance and trespass enforcement. In 2014, H.R. 409 and S165 addressed this in line with the bills 9 years ago in the 109th Congress, which was H.R. 4322 and S1439. And the NCII testimony was, to this point, having a Bureau of Indian Affairs and an Office of the Special Trustee as two completely separate agencies within the department is an awkward and an unnecessary arrangement. The administration opposed the legislation, arguing that termination of OST would jeopardize reforms put in place and would be a significant burden to taxpayers. It is the independence of OST that enabled it to make significant improvements to the fiduciary and accountability standards for managing tribal and individual trust accounts, according to the administration. However, they did say that appropriate management reforms for these functions will be informed by the Secretary's final evaluation, the final report of the Indian Trust Commission, and that work is ongoing, and we are hopeful they will come to the same conclusion as has this committee. Thank you very much.
Thank you very much, Will. Are there any questions on the third principle for trust modernization? Again, you can type your questions into the question box. You can also raise your hand if you'd like to answer the question over the phone. Okay, seeing no questions for the third trust principle, we'll head on to the fourth trust principle, which is strengthen federal and tribal relations. And for that, I'll send it over to Reed Chambers. Reed.
Thank you, Colby, and good afternoon. I guess it's probably afternoon everywhere by now to everybody. I guess the background on this is that when the President established the White House Council on Native American Affairs, he was really, in a way, resuscitating something that existed about 45 years ago. There was something called the National Council on Indian Opportunity, and that had been established by President Johnson by an executive order in 1968, the same day that he issued the first presidential message ever to Congress on Indian affairs. Now, I know looking around this table that there's nobody who remembered personally the National Council on Indian Opportunity, and probably there's not on the phone. I know, Dan, you've written on this and gone into the history of it, but I was actually there not in 1968, but in the early 1970s, when there still was a National Council on Indian Opportunity. It was it was chaired by the Vice President, and Humphrey, who was Johnson's Vice President, and then Agnew doesn't sound like the best pedigree for Vice President, since I think he's the only one ever to resign from office, but he was fairly actively involved in the National Council of Indian Opportunity, and the cabinet secretaries were. I think the change, Dan, am I right that Nixon made the change of introducing Indian leaders, or was that there originally?
When President Johnson established it by executive order in 1968, the NCIO included 6 members of the president's cabinet and 5 tribal leaders. Nixon ended up expanding the NCIO to add 2 more tribal representatives and 1 more federal representative, the Attorney General, so that there would be 7 of each, plus the Vice President.
Well, and there are a couple of things to say about it. The tribal leaders were very active participants in the council, and they had real influence on federal Indian policy, and particularly on the message that Nixon issued in 1970 to Congress, which is really the I guess you'd say the template for all future administrations in Indian affairs. So it was a dramatically important message, and it was heavily influenced by leaders like, I'm sure I'm going to forget some of them, but leaders like Wendell Chino at Mescalero, Roger Jourdain at Red Lake, Bob Burnett, I think, was involved from Rosebud, and there was a wife of a senator who was heavily involved, LaDonna Harris, who was the wife of Oklahoma Senator Fred Harris, and a Comanche member of the Comanche tribe. And this group really had an impact on what the Nixon message said and its implementation, going around and lobbying for the return of Blue Lake to the Taos Pueblo. So what's different in the 2013 White House Council on Native American Affairs is it does not include Indian representatives. And that is something the president could rectify and should rectify, and if he didn't rectify it, one of our legislative recommendations is that Congress do it for him. So I guess that really does, you've skipped over the administrative strategies, Colby, but that's the administrative strategy is that this should be rectified. This worked very well in the past. It can work very well now, and it's completely consistent with the Obama executive order and the Clinton executive order before it, requiring consultation and coordination with Indian tribes on any matter that a federal agency is going to do that impacts them. So this is something that if it's important Indian country, that Indian country should push for, and if necessary, push for having it regularized by legislation. And then I guess on the other legislative strategies that the group has put forward for Indian leaders to consider, there are some old treaties that required or provided for representation in Congress of particular tribes. And this is something that should be implemented and revisited. That's a proposal that we're putting forward before you. Elevating the Assistant Secretary of Indian Affairs to a cabinet level position within the administration so that there would be a Department of Indian Affairs. Ambassadorial status accorded to federal representatives in Indian country and Indian country representatives to the federal government. And then, and this is something President Patterson, I think you emphasized earlier today, but and I think Dan is correct that this will be a a long-term effort. But the implementation of the UN Declaration of the Rights of Indigenous Peoples, at least a pre and prior and informed consent for impact, for actions impacting tribes, that's something that Congress should enact. And when one of you is sitting here 40 years from now, maybe Katie or maybe Liz, kind of talking about how you remember when we started this in 2013 and 2015, and you were there, why you can report on the things that have been accomplished over the next 40 years. It's a proud agenda. Thank you.
Great. Thank you very much, Reed. Do we have any questions on the fourth Trust Modernization Principle? Okay, not seeing any, we'll move right on to the fifth and final Trust Modernization Principle, and that is for strengthen federal funding and to improve its efficiency. All the principles that you've heard so far presented today, a lot of them really won't be able to succeed without sufficient and effective federal funding, and this funding has been incredibly lacking in Indian programs and services. It's deficient for trust administration services, infrastructure, and contract support costs, all of which are required by treaties, statutes, and the federal trust responsibility. This continuing lack of funding policies will exacerbate the needs within Indian country, stifle tribal economies, and increase federal costs, setting the stage for a potential next generation of COBEL and trust mismanagement claims. Further, there's been the two reports, the Department of the Interior Secretary Commission on Indian Trust Administration Reform, which you discussed thoroughly today, and the Department of Justice Advisory Committee on American Indian and Alaska Native Children Exposed to Violence, both recently recognized a very important point that treaties and the trust responsibility are not discretionary. Full funding must be provided for Indian programs to be successful, and federal funding of Indian programs and the trust obligation should never be subject to means testing or any other inapplicable standards that are often leveled unilaterally by Congress or by federal agencies. For the administrative actions to implement our federal funding is to encourage federal agencies to propose budgets that fully fund the trust responsibility. The President's annual budget should also always include money that fully funds the trust responsibility, and Indian budgets should be handled through the mandatory component of the federal budget. There's two legislative actions. Would be for Congress to enact appropriations that fully fund the trust responsibility, and to enact legislation that amends the Indian Financing Act to provide tribal governments federal income tax revenues of tribal citizens, and otherwise modernize that act to foster economic activity on reservations. Are there any questions or comments on the trust modernization principles as they're presented so far? So either we presented you guys with so much information or we've done such an incredibly good job with thoroughly explaining everything, because I don't see any additional questions. Just so you know, we have contact information at the end of the slide to be able to reach out to members of the work group for more information, or if you have other questions that do come up. I think the next thing we'll do is we'll send it back over to Kiki to talk about sort of the next steps for the draft principles.
Well, first of all, thank you for everybody who called in and participated in today. I know we threw a lot at you and kept it at a high level intensively. What you also had, though, for today's webinar were the two draft documents, the strategies document and the principles document. Just a couple of things I want to reiterate that I mentioned earlier, especially if you joined us late. This work product that we are going over today resulted from many regions and parts of Indian country coming together and sharing the work that they had previously done on trust modernization and trust reform. It also included previous works on this effort over the last several decades. So the goal was to merge those as best we could to make sure that it was reflective of the various interests and priorities found across Indian country. So the first request that I have for everybody on the phone is to make sure that if what you heard today in the webinar or what you view on the strategies or principles document fails to reflect something that is of great importance to you, to make sure to bring those recommendations forward to us. Again, I want to stress that this is not the end of the process. This is the beginning of the process. These are draft documents that you're looking at, and we want to make sure that they are as broad and comprehensive as possible, because ultimately what we're looking for is unity across Indian country as we start to work these. That leads me to my second point. As you heard throughout today, you heard both an administrative strategy as well as a legislative one. Built into each one of those is both a short-term and a long-term strategy as well. So we have no preconceived belief that we're going to be able to have one effort that solves all these issues at once. We know that there will be opportunities that present themselves within the remaining months of this current administration, but we also know that there are other objectives that we've outlined that are going to be years in the making. Again, to reinforce the point that we didn't arrive here overnight, and it's not going to fix itself overnight either. What we are planning as one of the next steps that will come from this once we get further input and recommendations back and lead to a final document, at least the summary documents, a couple things to be looking for. One, with each one of these goal areas and objective areas, there will be a more detailed paper to accompany that. So as we all begin to advocate on various elements of this initiative, that you'll have the greater detail to go along with that. What we are also planning for and hoping for is a end of the year, possibly fall, winter time frame to have a much larger rollout of this, where we would invite tribal leaders from across the country, members of Congress, members of the administration, friends of Indian country, et cetera, to have not only a high-level conversation on these strategies and principles, but also to further unify around them and to all invest and make the commitment to invest in this. Again, at the goal of this entire initiative is to start redefining this relationship from an Indian country, tribally leader-driven perspective. I know all of us get frustrated at times of dealing with the symptoms that result from some of these systemic failures and shortfalls of the current trust model. So what this is an investment for the long term, so that at some point we can hopefully arrive at a different reality. So I would encourage all of you to take this information back to your regions. If you're interested in members of this work group making a presentation to your respective regions, we will be more than happy to do that. Please just make the request. Our goal is to be inclusive as possible. And again, if you have any desire to see any of the reports and various documents that we've referenced throughout today's webinar that were utilized in the drafting of these documents, please let us know as well, and we'll be more than happy to share that with you. So we'll be looking for more information once we are able to firm up some dates and some location availabilities. The event that I'm speaking of for the fall and December timeframe is intended to be held in Washington, D.C. But as we get that firmed up, we'll be sharing more information, so please looking for that.
We did have one question come up while we were going through the webinar. Another question from Kate Hoover, and she asked, one of the strategies defined as implementing UNDRIP, how does this apply to the relationship of tribal members with their own tribal governments?
I'll answer that unless someone else wants to jump in. This is Dan Rayburn. It is not our understanding that UNDRIP applies to issues in between tribes and their own tribal members, but rather the implementation that we are seeking is implementation of UNDRIP in terms of relations between tribes and others. That is our understanding of the free and informed consent that is addressed there, because it is in relation to states in the international context.
Will Micklin, and I'll just add to Dan's accurate answer. However, there has been some misinterpretation. The EPA made an unfortunate foray into indigenous people's issues with their recommendations for fostering environmental justice for tribes and indigenous peoples. They released that January 13th, 2013. And they have recently put out solicitations for further comment to it, and that is after Central Council's meeting with the administrator to talk about some of the unfortunate language within it, where an EPA positions itself to represent the interest of individual tribal members and non-tribal members on tribal lands for issues that they would have with the tribal government. We think that's unfortunate and unintended, as was communicated to us by EPA officials. And so I think there'll be a revise of that document as quickly as we can accomplish that. But it goes to the point that Mr. Rayburn was making, was that UNDRIP does not undermine tribal government authority. It in fact supports indigenous governments and the collaborative efforts of tribes across the country, including Navajo Nation, Chickasaw, Cherokee, Mohegan, Central Council, many others, has been to create a permanent and regular role for indigenous governments, all indigenous governments at the United Nations, that is now occupied by NGOs and non-government organizations that speak for tribes, because we can't speak directly to in those forums. So we're hoping to resolve the unfortunate issue at EPA, and with that, hoping to move forward. The disposition of UNDRIP in this administration is a little on balance. We've had some difficulty in getting references, even citations to UNDRIP in consultation, as in the Fish and Wildlife Service Native American policy that's under redevelopment. Interior Solicitor has had real problems with citations to UNDRIP and any expression that it is a guiding principle for the U.S. government, our trustee. And so we need to resolve that, but it's going to take some education and further work with this and the next administration to accomplish that. Thank you.
Great. Thank you very much, Dan and Will, for answering that. Just in closing, as you know, trust modernization is something that has been, as we've talked about, is something that's not any country's been asking for decades. And in some of the work that we've been doing in this, we actually found an NCAI resolution from 1959, which cites a couple of the following points, which probably are going to sound very familiar to what you've heard, asking for the Department of the Interior to allow each tribe to create their own development plans for the land and trust assets, to focus on developing and protecting resources rather than the termination of the federal trust responsibility, appropriate annual funding levels to carry out the trust responsibilities, and allow tribes to make determinations regarding the disposition of their lands and resources, as well as the transfer of any services. NCAI has got to be part of this large working group with all the intertribal organizations and tribes that are represented. We've been working with the group since it started in 2014, and we'll be building off of the different meetings that we've held at our meetings this past year, and we'll be also hosting a Trust Modernization Workgroup session at our mid-year conference at our annual session, which will be on Sunday, June 28th in St. Paul. So we hope to have all of you there to continue the discussions and conversations that stem from this webinar and from the draft strategies. With that, I'd like to thank. Okay. With that, I'd like to turn it over to President Patterson to make some closing remarks.
Hello? Am I live?
Yes.
Okay, good. In my opening and in my closing, I was trying to chime in the opening. I was already talking, but glad I got to be connected. I just want to emphasize the deep felt gratitude for everyone on this call for the effort, right? You know, we know this is centuries in the making. We know it's critical. It's an obligation that we owe to our future generations. Yet I feel very strongly and compassionate to stress the unity of this effort moving forward across Indian country in its wholeness. In order to be effective, we must not be afraid to vision. The vision of this document moving forward is critical. It's complete in a holistic approach. I'm sure we haven't covered every single base. And so for those on the call, any thoughts, comments, observations you may have to share will be critical. But again, I cannot stress, more importantly, the unity across Indian country to secure a brighter and stronger future so that we don't have to continue to relive some of the nightmares that are unfolding from the ineffective delivery of the trust relationship. Tribal nations across the country need to stand with vision, and I think we have shown through this effort of developing this draft document that we have the capacity to affect that vision. But only our unity can drive this forward. I want to thank everyone on behalf of the esteemed leaders of the United South and Eastern Tribes. I want to recognize the hard work of National Congress of America, NCAI, excuse me, and just feel really grateful to begin to think of the future generations of Indian country. Thank you.
Thank you very much, President Patterson, for that closing. With that, I'd just like to thank President Patterson and President Clasby for joining us today, and also thank our other panelists, Dan Rayburn, Kiki Carroll, Greg Smith, Reed Chambers, and Will Micklin for their comments and presentation today, and also thank our Trust Modernization Workgroup for putting all of this together. Again, we'll be sending out a link with a YouTube video of this, so you'll be able to watch it and catch some of the moments you may have missed, or play back your favorite components of it. And we'll also include the PDF of the PowerPoint slides for your reference. With that, there was contact information if you have any additional questions about the Trust Modernization Workgroup, or have any or like to join or get more information about it. With that, thank all of you for attending. We really appreciate it, and we'll hopefully all see you all at the next Trust Modernization meeting.